Hi, and welcome to Mike on Politics. Today we are looking at the New Zealand Constitution. There's obviously a bit of stuff going on in all around the country relating to the Constitution and the Treaty of Waitangi. And I want to delve into that a little bit more. If you haven't seen my first videos on critical thinking, a lot of time here thinking about critical thinking and being informed. So if you want to know more, have a look. If you want to disagree, then please be informed and let me know your opinions. We'll start here with the New Zealand Constitution. So obviously that's the New Zealand coat of arms, and really does show, if you zoom in, all of the aspects of the monarchy, Māori, our trading, and various other bits and pieces. I'm not here looking at that at the minute. We are starting off with some background. So the background I've used here is my old legal textbook, and then I've looked to update the information as I could. We've started here with the Introduction to the New Zealand Legal System by R.D. Mulholland and amendments as they've come through. So New Zealand has an unwritten but well-defined constitution. We are not the same as the USA, who have one written document and obviously amendments they seem to love. We follow the British model of an unwritten constitution built up of government acts of Parliament, New Zealand, and common law legal case law and court decisions, and British case law, and least likely but other Commonwealth case law. New Zealand is a sovereign, independent, unitary state with a constitutional monarchy. So we still have a king, a responsible government most of the time, and single house legislature. So we have a parliament and we have district councils, not states. We are just one country without states. The sources of the New Zealand Constitution is different aspects to it. The legislation, important from a constitutional point of view. We have and some of this has changed since my book was written, so I've updated it. The Constitution Act 1986, New Zealand Bill of Rights Act 1990. That's Bill of Rights Act's one of my favourites. The Electoral Act 1993. Effectively the Judiciary Act of 1908, replaced with the Senior Courts Act 2016. The District Courts Act 1947, replaced with the District Courts Act 2018. Other relevant legislation in setting up institutions and or protecting individual civil liberties, or in spelling out New Zealand's relationships with other nations. There's the Acts and Regulations Bills 1989, Civil Lists Act 1979, replaced in parts by the District Courts Act 2016, and Members of Parliament's Remuneration Act and Services Act 2013, Continental Shelf Act, I don't know what that is, Crown Proceedings Act 1950, Foreign Affairs Act 1988, Geneva Conventions Act 1958. It's obviously pretty important after different acts of war and things like that in the past. Human Rights Act 93, Imperial Laws Application Act, Legislature Act 1908, and that's been superseded by the Constitution Act 1986 and the Legislation Act 2019. Local Government Act 1974, mostly repealed and largely replaced by the Local Government Act 2002. Ombudsman Act 1975, Parliament Services Act, Privacy Act, State Sector Act, State-Owned Enterprises Act, and the Treaty of Waitangi Act 1975. We also have conventions. These are common law conventions of Parliament, Governor-General, and the Judiciary. Standing orders of Parliament, proceedings and their behaviour. The functions of the Governor-General, the office of Judge affords protection of the Judiciary. Another aspect is the rule of law, although some of these rights are now codified in the New Zealand Bill of Rights Act 1990. The legislation is in no way diminishes or reduces from the common law principles. All are subject to the law. So the Legislation Act 2019 actually says that the Crown is not bound unless an Act of Parliament expressly states it. So no Act or Part Act binds the Crown unless the Act or legislation expressly provides that the Crown is bound by the Act. And you'll see most Acts state in the beginning, this Act binds the Crown. So the RMA, Local Government Act, Treaty of Waitangi Act, things like that. So many totalitarian states do not have this convention. So New Zealand is a democratic country, and all of these aspects build our constitution and our place in the world and how we see other countries. And I guess if we can throw stones in a glass house, all persons are equal under the law. So that means members of Parliament, judges, everyone is equal under the law. Courts are open to all. Any citizen may resort to the judicial process to redress a grievance. The legal process is conducted in public for all to see. Important legal decisions are published in New Zealand law reports, and laws are published and made available online now, which is actually really handy because they show what's repealed and what's not, which is good. Most decisions which affect the right of individuals are arrived at following an established procedure, which is predetermined and must be followed in order for the decision to be lawfully made. Legal judgments follow legal precedent of previous decisions, so case law builds up upon itself. No person may be proceeded against or suffer any penalty except in accordance with the law. So in New Zealand, all crimes are set out in statutes, and unless it's specified, it does not amount to a criminal offence. So a crime has to be written in statute for it to be illegal. Letters patent. These are a set of instructions issued by the Governor-General, or to the Governor-General by the monarch, and instructions to the Governor-General as to constitutional protocol. So the Governor-General is the representative of the sovereign, the King or Queen of New Zealand, and the title of the sovereign is currently His Majesty King Charles III, King of New Zealand and of his other realms and territories, head of the Commonwealth. So the King gives letters patent to the Governor-General. The Governor-General can assign bills into law, accepts the will of the electorate, and appoints the leader of the majority party in the House of Representatives as Prime Minister, is the ceremonial commander-in-chief of the military, and has some really used powers. Can dismiss a minister or prime minister, can veto a bill or not give royal assent, not assent the bill into law, dissolve or refuse to dissolve Parliament. So if Parliament wanted to indefinitely extend their term, Governor-General could dissolve Parliament. Imperial enactments in force of New Zealand. So Imperial Laws Application Act 1988. So the surviving laws are mostly foundational common law statutes, classic constitutional instruments of the United Kingdom that New Zealand has chosen to retain as part of its legal heritage. Schedule 1 includes the Magna Carta, so some really great historical legislation here that gave right to the British Parliament away from the King. And there's some really interesting historical YouTube videos and all sorts of things on that and how that came about and how Parliament took the right off the King. And New Zealand has inherited that. And this stuff's all pre the Treaty of Waitangi, so we'll go into the Treaty of Waitangi later. But having these rules set in law and how old they are, so we've got Magna Carta 1297. So that is, that's very old legislation, confirming the rule of law and due process rights. That Yeah, absolutely foundation. Petition of Right, 1628 in the UK. The petition sought recognition of four principles: no taxation without the consent of Parliament, no imprisonment without cause, no quartering of soldiers on subjects, and no martial law in peacetime. And the USA could probably look at that at the moment. Bill of Rights, 1688 in the UK, which underpins parliamentary privilege and constitutional monarchy. Habeas Corpus Act, 1679, often called the Great Writ, that allows a person to challenge the legality of their detention. It requires a court to examine the reasons for a person's imprisonment, and if the detention is found to be unlawful, the court must order the individual's release. It is a fundamental right in many countries, protecting against unlawful or arbitrary imprisonment. Act of Settlement, 1700. The Act of Settlement is an act of Parliament of England that settled the succession to the English and Irish crowns only to be Protestants, which passed in 1701, which is pretty random. But more specifically, anyone who became a Roman Catholic or who married one became disqualified to inherit the throne. So I don't know why New Zealand still has that, but we do. Certain sections of the Commonwealth of Australia Constitutional Act, 1900, are relevant to New Zealand's relationship with the Commonwealth. These provisions sit alongside New Zealand statutes like the Constitution Act 1986 and the New Zealand Bill of Rights Act 1990, forming part of the wider constitutional framework. And then we have the Treaty of Waitangi, 1840. So obviously some of those British acts were hundreds of years before the treaty, and the Treaty of Waitangi now is 185 years old, so still going strong. It was signed by Captain William Hobson on behalf of the British government and 500 Maori chiefs. There's both an English and Maori versions, and the different interpretations due to different languages interpretations of key words. That's probably the biggest issue with the treaty, and I'm going to do a whole nother video on the treaty and the history behind it, and how both parties came to an agreement and a treaty. So the Treaty of Waitangi in 1840 was enshrined effectively in the New Zealand Constitution in the 1975 Treaty of Waitangi Act. And the Treaty of Waitangi Act 1975 gave the Treaty of Waitangi recognition in New Zealand law for the first time and established the Waitangi Tribunal. The tribunal is empowered to investigate possible breaches of the principles of the Treaty of Waitangi by the New Zealand government or any state-controlled body occurring after 1975. It was also empowered to recommend but not enforce remedies. And there obviously significant case law and Waitangi Tribunal set up for that. The preceding governments have obviously engaged with local iwi for settlements, and that process has been going on for 20 or 30 years, which we will touch on. But really I want to give in the next video actually more background into the Treaty of Waitangi and bringing how the parties came together, and that video will be based quite heavily on the penguin history of New Zealand, and that goes by Michael King, and that is brief. On the back it says, New Zealand was the last country in the world to be discovered and settled by humankind. It was also the first to introduce full democracy. Between those events and in the century that followed the franchise, those movements and the conflicts of human history have been played out more intensively and more rapidly in New Zealand than anywhere else on earth. And quite an outspoken country, and things swing in roundabouts, so this will be quite interesting. Hopefully the narrative that emerges is an inclusive one about men and women, Māori and Pākehā. It shows that British motives in colonising New Zealand were essentially humane, and that for Māori, far from being passive as victims of a fatal impact, coped heroically with colonisation and survived by selectively accepting and adapting what Western technology and culture had to offer. There's obviously also grievances and land that's been stolen. There are redress beyond that, we will go into the beginnings of that, and I guess the full redress and things is an ongoing debate at the moment, but we will give hopefully some nice background of how both sides have come together and effectively agreed a treaty. That some people, there is difference in the wording, but by and large, both parties were willing buyer, willing seller. They had a mutual agreement that still stands today. And in the news, we've had the Regulatory Standards Bill 25. So the Public Service Act 2020 includes a specific clause that explicitly requires the public service to support the Crown relationship with Maori under the treaty. In contrast, the proposed Regulatory Standards Bill is criticised for its potential negative impact on the treaty, as it omits any explicit reference to the treaty's principles and could weaken Maori rights by creating a legislative filter that prioritises other criteria. And this is likely a stealthy and crafty attempt at constitutional change that likely won't last the next change in government. Similar to the Labor government here tried to entrench the Three Waters legislation a few years ago by requiring a supermajority of 60% of Parliament to change the law in the future. So they could pass the bill with 51% and then said, you need 60% to change it, which I don't think is overly constitutional. This 60% wasn't included in the final act, I don't believe, and the act was repealed by the national government, probably similar to how the Public Services Act Public Services Bill of 2025 will. And I guess my comment here is that any constitutional change should have, in my opinion, that 60 or supermajority, 2/3 majority, 66, effectively requiring both major political parties, National and Labour, to agree, which is highly unlikely to happen. So we will probably keep a unwritten constitution for some time, until such time as they can both grow up and agree what that should look like. And in the current political climate, that I would say is unlikely. So I hope you've enjoyed this. I hope that gives you some background on the New Zealand Constitution and the historical and British background. And I'll leave that picture there that shows, the New Zealand coat of arms and our history. I'll leave it there. Thank you.